that thing different from another brand. And if you do not want that to be out, you can actually protect it by trade secret. Now, while that's not so popular here, so that you don't have penalized for it. So that's the rationale behind trade secrets. So I believe I've been able to digest 4 of these types of industrial designs. Did I mention industrial design?
No, you haven't done that yet.
Okay, so now industrial design is the applicable design, the applicable creative design. So when you have your copyright, maybe it's paper format, right? You draw a particular thing. Maybe you have an illustration of your fashion design in paper or in digital format. By the time you're able to reproduce that in a form. So now, like this Ziva design is a 2-piece shirt and pants, right?
Yeah.
The entirety of that form was protected by industrial design. A very popular example would be the Ugomoye case that happened sometime maybe 2 or 3 years ago. I can't remember, where Eddie Murphy used one of his designs, one of his clothing for the Coming to America 2.
Yeah.
Then he was going all out saying, oh, I had protected this by patent, I had protected this by trademark. But the issue there was he didn't protect it by industrial design, and that's how he couldn't enforce that. So it's one thing to know that you have an intellectual property right. It's another thing to ensure that you protect it in the proper manner. Oftentimes people confuse all of these intellectual property rights. So in your design, there's the copyright, that's the image itself, in the artwork. There's the trademark, that's the brand identity, maybe logo itself, how people can identify you. Then there's the industrial design, that's the entirety of that design in applicable form, in tangible format. Okay, let's go back to Coke so that we can easily relate. You see the Coca-Cola bottle. Someone that is blind or someone that's not seeing properly, or someone, if you're trying to play a game and you hold the Coca-Cola bottle, the form, the shape of that Coca-Cola bottle, you can tell this is Coca-Cola and it's not any other cola drink. That particular form, how it is made, is definitely different, even though it might look similar to some other things, some other brands, right? It's different. It's just protected by Coca-Cola. So that's where industrial design comes in.
Wow. That's you've said quite a lot. For a new startup or small business, what is the most critical type of intellectual property to protect first, and what should be their immediate priority?
Okay, I would say trademark right.
Trademark right. Now, tell us why.
Yes. The reason why I say trademark right is before you talk of marketing, right? Before you talk of even making money, your name goes ahead of you. If you want to market a particular product, what are you marketing? You're not just bringing that product to me and say, oh, buy this. What are you buying? That identity. It looks like it's something small, but it's a big deal because you don't know where you're going to. Your intellectual property right is a gold mine. So you have to protect even before launch. Every time I tell creatives, before you launch, you should actually secure that trademark right. That's what keeps that name to you. That's what locks up that name for you, that logo, that slogan to yourself. So now I would say copyright is not, the reason why I'm not saying copyright is this, statutorily, right? What the law provides is copyright is an automatically generated right. So you do not necessarily have to register your copyrights, unlike trademark. So copyright is the only intellectual property right that you don't mandatorily have to register. So all you need to do is put out that work in a form. If it's in your head, nobody's protecting what's in your head because we are not God. We can't see what's in your head. So all you need to do is put out that work. This is my artwork. This is my fashion design, and automatically it's protected by copyright, right? But your trademark right, if you do not protect it, if you do not register it, I'm sorry, it's a lost case. If somebody else goes ahead, you see this Ziva brand, unfortunately, let me not say unfortunately because I don't know what the situation is. If that person imitating decides to trademark Ziva, assuming Teni Omotayo's brand has not trademarked Ziva, do you know that person has right because it's a first in time right? That's how trademark works. First to protect.
The first to protect.
The first to protect. So we can all say, oh, we can support Ziva and say, oh, this is I know this logo, this is Ziva's logo. And then maybe because she actually dropped a comment that I found really interesting. She said a 1,000 page follower, I can't go ahead suing them because they just, so people are relying on, this brand is not so popular. They just have 1,000 followers, and that's not the fact and issue here. Whether they have 1,000 followers or not, if they decide to trademark that name, that logo before you with the 1 million followers, then no one's going to really help you out here. You have a long case to work out in court to prove that you were the original owner. So trademark right is a first in time protection. So you need to do that as soon as the thought is coming to your mind. Even if you're not certain how much you have to invest in this brand, you should at least lock up that brand identity to yourself. That's it. The rest can follow suit. Of course, the industrial designs can also follow suit. It's actually a whole lot to do. You need to just keep working as you go. It's not only just to market and make the money. Reputation might be at stake in the long run. Your image might be at stake in the long run. So you don't just think of, I need to just make some money out of this business.
All right. Yeah. If you're just joining us, we're still talking intellectual property for businesses. And my guest is Omotayo Abiode. She's an intellectual property lawyer. So far, so good. We've been able to identify the types of intellectual property that a business should be aware of. The most critical type of intellectual property to protect first. Now, Omotayo, beyond legal registration, what other proactive measures can a business take to build a strong intellectual property portfolio? For example, how should they handle intellectual property created by freelancers? Because you do know that a lot of businesses have freelancers attached to them. You also mentioned employee and the instance you gave about the Coke brand. So somebody that leaves that company cannot go and now replicate everything that they have seen, trade secrets and all. And then, of course, you know that businesses from time to time will have collaborators.
Yes, of course. Can I answer that now?
Sure. Go ahead.
Okay, so aside registration, right, you need to focus on your contracts.
Your contracts
are backbones for business owners. You can't ever joke with your contract. So for the copyright, the Copyright Act provides that when you create something, the author. So when I'm saying author, it's not necessarily a book work. That's what the Copyright Act is. The creator is also called the author. The author automatically has ownership in that thing. Of course, to every law, like we say, there's an exception. So now this is where exception comes. When you are an employer of labor, you have creatives working for you. The first owner of whatever they produce for you under that employment relationship belongs to the employer. Here's another